Welcome to week 2. We start the semester with legal issues for a number of different reasons. One, because employment law covers every aspect of the employment relationship. All of the topics that we will learn about in this class are related to employment law. Also, because legal issues are related to ethical issues. The law and ethics are not the same thing, but they are highly related. Also, because legal issues can cause a lot of problems for organizations. They can be costly, sometimes resulting in fines in the tens of millions of dollars. They can damage organizations' reputation. They can also lead to a loss of control. In some situations, in some cases, organizations lose control, some control of some of their HR functions after losing a lawsuit. And then finally, and probably most importantly, these legal issues can be resolved before they become lawsuits. So it's important for us to understand a little bit about employment law so that we can minimize the risk of lawsuits. The Equal Employment Opportunity Commission, the EEOC, is a federal agency that is responsible for monitoring and enforcing equal employment opportunity laws. And these laws are designed to prohibit, to prevent, to minimize employment discrimination in the United States. The EEOC can do two primary things. One, they can investigate complaints of employment discrimination and harassment. Two, they can file lawsuits against organizations for violations of the law. There are two primary types of complaints that the EEOC investigates. Employment discrimination includes any decision that favors one group over another group or other groups. Harassment is a type of discrimination. It involves unwelcome conduct based on someone's personal characteristics, their age, race, gender, religion, sexual orientation. These are the two main types of cases that are investigated by the EEOC. A third responsibility of the EEOC is to issue guidelines, to publish information that helps employers ensure that they are following employment law. I have a couple of examples here of the guidelines that they've published in years past. The first bullet point, the Uniform Guidelines on Employee Selection Procedures, is a guideline that you may have to read in grad school. It is most useful to personnel psychologists because we spend so much time on selection. Finally, the EEOC requires that employers with more than 100 employees submit a document that helps the agency determine possible patterns of discrimination within organizations and across regions. Who can file a discrimination complaint? Anyone who believes their employment rights have been violated. You can also file on behalf of someone else. What are the time limits for filing a complaint? Typically, under most laws, the time frame is 180 days from the day of the alleged violation. What agency handles cases related to state and local laws? A state-based Fair Employment Practices Agency, a FEPA, dual files with the EEOC. Are international companies covered by the EEOC and EEO laws? Yes, in most situations, U.S. companies that employ U.S. citizens outside of its borders or its territories are also covered by EEO laws. Let's look briefly at some of the most important employment laws that are relevant to personnel psychologists. Title VII of the Civil Rights Act of 1964 prohibits discrimination and harassment based on a number of factors: race, color, ethnicity, national origin, including birthplace, ancestry, culture, or linguistic characteristics, religion, and sex. This law applies to employers of 15 or more employees. There are a number of exceptions to Title VII. When the trait in question, for instance, age, is a reasonable necessity to the business's operations. We call this a bona fide occupational qualification, a BFOQ. Age can be a BFOQ in some situations. Take airline pilots, police officers. There are a number of industries that mandate retirement at a certain age. This mandate to retire is not considered discriminatory because at a specific age, 50 in some industries, 55 in other industries, at a specific age, it has been shown that employees begin to make more mistakes, more errors, cost the company more money in terms of accidents, fatal accidents. Sometimes those qualities are BFOQs. Another exception is when discrimination is based on seniority systems, veterans' preference rights, national security, test scores, experience. It's not discriminatory if you can back up with performance data that a specific person deserved or didn't deserve a promotion, a raise, an employment opportunity. Finally, some private clubs, religious organizations, and employers on Native American reservations. In these cases, these organizations are protected from Title VII violations. There are two types of discrimination covered by the Title VII regulations. Disparate treatment is the intentional kind of discrimination. This occurs when an employer knowingly, purposefully discriminates against a specific group of employees. It can come in the form of retaliation. Retaliation is also outlawed. Disparate impact, also known as adverse impact, is the accidental kind of discrimination. This occurs when an employer accidentally, unintentionally, doesn't mean to discriminate against a group of protected class individuals. We use what is called the 4/5 rule, sometimes called the 80% rule. We use this rule to assess whether or not adverse impact is present. Here's an example of how we might use the 4/5 rule. You can see applicant data. We have 3 different groups of applicants. Some were hired, some were not. We look at the hiring rate and compare the hiring rate across groups to determine whether adverse impact has occurred. The majority group in this case, it's not always the case, but in this particular case, the majority group is the group of white applicants because we had 50 white applicants, hired 10. So there were more white applicants than any other group. Therefore, we use that group and compare all the other groups to that specific group. So the hiring rate for the white applicants is 20%. You take 10 divided by 50. Because it's the majority group, we apply the 80% rule, the 4/5 rule to that hiring rate. 80% of 20% is 16%. 16% is then going to be the standard at which we compare the other groups. So let's look at the African American hiring rate. 25 applicants applied, we hired 5. 5 divided by 25 is 20%. 20% is greater than 16%. So the hiring rate for one of the groups is greater than 80% of the majority group. So in this case, there's no adverse impact for the African American applicant group. Now let's look at the Hispanic Latino group. We had 20 applicants apply. We hired 2. 2 divided by 20 is 10%. Now, 10% is less than 16%. And because of this, because we hired only 10% of this particular group, and that is less than 80% of the majority group in this case, yes, we have evidence of adverse impact. When it comes to selection tests and Title VII, the plaintiff, the employee, the one making the complaint, must first present prima facie evidence of discrimination. They have to demonstrate that they are, in fact, part of a protected group, and they have to demonstrate that this group was disadvantaged by the employer's decisions. The defendant, the employer, can then refute the evidence and show that the decision was job-related and based on job-related information. In the case of a selection test, the employer might provide evidence that there's a significant, strong relationship between test scores on the selection test and job performance. They can also provide other types of evidence regarding the validity and the reliability of selection tests. Sexual harassment involves unwelcome sexual advances, requests for sexual favors, or other verbal or physical conduct of a sexual nature. There are 3 other criteria that we normally look for in a sexual harassment case. When the submission is made explicitly or implicitly part of employment, when the submission or the rejection to such advances, requests, is used as the basis for other decisions about employment, including raises, promotions, assignments. And finally, when the unwelcome conduct interferes with the employee's life, when that conduct makes it difficult for them to get their job done and to do their job well. With sexual harassment cases, there are a number of factors that, if present, make it more likely that the plaintiff, the employee, will win the case. If the harassment involved physical contact, if the propositions were also linked to threats or promises of a change, if the exchange was quid pro quo, I do this for you, you do this for me. If the plaintiff notified management before filing and the problem was not resolved, if the claims can be corroborated by other coworkers, and if the organization had absolutely no sexual harassment policy put in place, no training put in place. If all of these factors are present, the organization is going to have a tough time defending their position. There are a number of ways that we might minimize the incidence of sexual harassment in our organization. 1, make sure the company has a written, formal policy put in place, a policy that is communicated to employees, a policy that is easily accessible. 2, make sure there is a grievance procedure put in place for both alleged victims and witnesses to report inappropriate behavior to managers. Make sure that the organization has some type of training program that communicates these expectations and shares with people exactly what sexual harassment is, what to do, what not to do, and shares information about the grievance procedure that I just mentioned. Most importantly, anytime an employee complains about sexual harassment, that complaint should be taken seriously and handled quickly. Do not let these issues fester. If the employer does not take care of the issue, it may be the case that the employee seeks the aid of the EEOC. Affirmative action is the extent to which an employer tries, through their HR policies, practices, procedures, tries to attract, select, and keep a diverse group of employees. Companies who are high in affirmative action actively recruit underrepresented groups. They change management practices and try to influence their employees' attitudes when necessary. And they also eliminate discriminatory practices as soon as they are made aware that those practices are a problem. Affirmative action is required by government contractors and subcontractors with contracts worth more than $50,000 and with employees, 50 or more employees. Both voluntary and involuntary affirmative action plans should follow a few guidelines. They should attempt to fix old patterns of discrimination within an organization. These patterns can be discovered through data from the organization and data from employees. There is no need for rigid quotas. The plans are designed to enhance the attractability of the organization, to enhance the size of the applicant pool, and ensure that everyone is truly getting a fair shot at employment in that particular organization. These plans are often temporary and they should be flexible, mostly because the plans continuously change. These plans do not ignore the interests of the majority group. That is not the point of these plans. The Civil Rights Act of 1991 is also important to personnel psychologists. This particular law clarifies the obligations of both plaintiffs and defendants under Title VII. There were some questions that kept coming up in lawsuits, and so the Civil Rights Act of 1991 attempted to clarify those questions. This law allows for jury trials and compensatory and punitive damages for intentional discrimination. It also extends the protections to some congressional employees and political appointees. They were not covered under Title VII of the Civil Rights Act of 1964. The Act of 1991 protects U.S. citizens working for U.S. companies on foreign soil, and it prohibits quotas and subgroup norming. These are two things that have to do with data and standards, and you cannot use either one of them. The Age Discrimination in Employment Act of 1967 prohibits discrimination against employees aged 40 or over. In these cases, the plaintiff must prove that age was the determining factor, the number one factor for not being hired, promoted, compensated, or for being laid off, terminated. They also have to prove that they can satisfactorily perform the job and that a younger person got the promotion or got their job. All three of these criteria have to be in place in order for an Age Discrimination in Employment Act violation to be taken to court. The courts have recognized that in some cases, age ceilings are necessary for physical fitness, and when people at that age can no longer perform the necessary functions of the job. So the ADEA of 1990 prohibits discrimination against individuals with a disability who can perform the essential functions of the job with or without reasonable accommodations. The ADA also prohibits employers from asking employees about their disabilities prior to offering them a job. The ADA also limits the use of medical examinations and testing prior to a job offer. So in many cases, if an organization is interested in accommodating an employee who appears to have a disability, that conversation should not be had until after the employee is hired. And that disability cannot be used to not hire that individual. The ADA applies to private sector employers with 15 or more employees. It requires that they provide reasonable accommodations. They are not intended to pose what is called undue hardship, financial administrative hardship. When the courts are trying to determine whether an accommodation is or was reasonable, they often look at the size of the organization, the type of organization, and also the nature and the cost of the accommodation. An amendment made in 2008 expands the definition of major life activities and major bodily functions and requires that disabilities be permanent and assessed in an uncorrected state. So for instance, vision, the employee would need to be evaluated without their contacts in. The Equal Pay Act of 1963 prohibits compensation discrimination on the basis of sex. When we're trying to determine whether compensation discrimination based on sex occurred, we require that the jobs be similar. They do not have to be identical, they have to be similar. Under this law, we can also consider differences in skill, effort, responsibility, working conditions when we're trying to determine compensation. We can pay differently based on seniority, merit, work quality, and quantity, but it cannot be based solely on sex. We cannot reduce the wages of either sex to equalize the pay. The lower paid group must be brought up to the higher paid group. And the Equal Pay Act overrides labor union contracts. The Pregnancy Discrimination Act of 1978 prohibits employment practices and decisions that discriminate against pregnant women or individuals who are interested in becoming pregnant, or individuals who are adopting children, or individuals who have related medical conditions. Under this law, employers cannot refuse to hire a pregnant woman if she can perform the essential functions of the job. Employers must also provide benefits for pregnancy as they would with other medical conditions. And the PDA does not guarantee employment after pregnancy leave, but the FMLA attempts to resolve that issue. This law was passed in 1993, and it mandates 12 weeks of unpaid family leave per year for certain medical conditions. The Family and Medical Leave Act, remember, there's that second piece of it, the medical part. It's often associated with family situations, pregnancy, but it also applies to other situations, medical conditions. The FMLA mandates that employees return to the same or comparable job. Unfortunately, FMLA only applies to employers with 50 or more employees. There are many people working in small businesses that are not covered by FMLA. This law applies to employees who have been working at that employer for at least 1 year and have clocked at least 1,250 hours. Employers can ask for medical documentation from the employee's doctor, and they can exempt the highest paid 10% of the organization. When it comes to employment termination, there are a few things that employers need to consider. Some employers are required to provide a temporary continuation of an employee's health insurance benefits after termination. It's usually a good idea to notify employees of their potential eligibility for unemployment benefits. It's also usually a good idea to allow them access to their vested retirement plans. You could have a lawsuit on your hands if you don't. Check with your state's laws regarding that final paycheck. In 49 of the 50 states, employees can be terminated at any time for any legal reason. We call this standard the employment at will standard. This is relevant to all states except Montana. Now, employers still have to uphold the other EEO laws, but they are not mandated to provide reasoning behind an employee's termination. Now, if that reasoning is found to be unlawful or discriminatory, then that employer can still be taken to court and may get in trouble for those particular practices. Just cause standards are usually seen as more fair. In this case, employers can only terminate employees for a reason, a good reason, a just cause. If an employer decides to apply the just cause standards because they're more strict than the employment at will standards, if an employer decides to follow the just cause standards, it becomes even more important for them to document performance data and appraisals. Fortunately, there are a variety of strategies we can use to minimize the likelihood of employment discrimination. First and foremost, always rely on work analysis data. Validate selection tests before administering them. Communicate policies to all employees. Document performance measurement decisions and the performance appraisal process. Base pay on job analysis information and job evaluations. Stay up to date of any changes to federal, state, and local laws, which is quite an assignment, I assure you. You want to make sure that your leaders and your managers understand the legal environment as well. And finally, never, ever, ever retaliate. It is forbidden and can make the situation much worse.